did you accuse me of forum shopping after I appealed what was completely a ludicrous misrepresentation, a miscarriage of justice, except it was actually a telebortion of justice? Is that a term? Telebortion of justice? It might be now. I'm just gonna do something. I'm gonna go shopping in my own store. It's not actually a store. What it is it is my actual computer business software and what I do and put onto my own business account. But the thing is, for a long time, actually, ever since I've been in Texas, there's always this second account, and I always get remanded to the second account because something always happens. The first time, every fucking time, I try to set up an electronic account, even if I purchase my own business software, even if I purchase my own damn business license. Everything ends up having a first account, and then something goes wrong, so I have to open up a second account, and then I end up getting pinged. Wait a second, somebody attempting to pretend that they're you is claiming that somehow they've got something they're going to work with. I have a theory. You see, this whole thing had something to do with contract. There was one word in the contract. The wrong arguments. This is a big problem we've been having. Certain people have been trying to hyperinflate the profundity of certain concepts and context for presentation. And what it has done is it has allowed for a trajectory that has stacked the deck in one particular direction to the detriment of all kinds of other things. I asked this question once. I said, when you're discussing constitutional law, including if you're in a situation where you got to review constitutional precepts and you decide, for instance, for that session, or maybe in particular context, what you're going to evaluate, do you have to give parity? They talk about equal treatment. What about parity? Is there parity before the law? Do you have to have a certain kind of balance when it comes to considerations of precedence and context related to constitutional amendments? If you just ignore the Fifth Amendment for a while, or you just ignore the Eighth Amendment for a while, does it have an impact in the long run? Let me ask you a question. When was the last time an actual 13th Amendment argument was taken to the Supreme Court of the United States? Let me ask you another question. When was the last time a charge of terrorism was taken to the Supreme Court of the United States, or even to an appellate court that involved people from, say, the Bible Belt? Right? Literally, the Bible Belt. I mean, these are very important considerations. So let me just go and say I did this thing. I actually transcribed it on the 10th of July, right? But I'd been considering it for a while. I got these notes one day. I was looking through a book on contract law. What is this? What does this say? I always do this thing. I timestamp even when I'm doing research. What does this say? What day was this? Hopefully I wrote down the time and everything. What the day, the time. It was within a couple of days of this that I started actually getting this research. Let's see. Well, I cited an article here, but the information online right now is a transcription of a voice file I did where I was reviewing notes. I'm gonna go shopping. All right, let's start here. It is from a book, A People's History of the Supreme Court with a foreword by Howard Zinn, written by Peter Irons. Page 114 of the book. Quote, the original fraud of the Yazoo land grants did not bother Marshall. Just one question concerned him. What is a contract? The answer was simple. A contract is a compact between two or more parties, whether private parties or states. Proceeding from this premise, the only obstacle in Marshall's path was Georgia's claim that sovereign states could revise contract laws without regard for constitutional limitations. Marshall declared that Georgia was not a sovereign power and could not pass laws impairing the obligation to contract. His ruling stemmed from the statement of Justice James Wilson in Chisholm v. Georgia in 1793 that Georgia is not a sovereign state. Judicial nationalism reached new heights in the Fletcher decision, but states' rights advocates could only deplore Marshall's decision. His opponents knew that efforts to reverse the outcome through constitutional amendment would be futile. And that's a direct quote from the book. What did I say? Now, this is a quotation by Mr. Irons, and it's supported with a foreword by Mr. Zinn, and that's no small matter. Then I give a context for when I read this and stuff like this, which I thought was important because it just demonstrated that while I was on my actual job, I was also enriching myself because I was allowed to engage in personal study. So, what kind of personal study was I doing on the job? Well, I was reading a book. It was called The People's History of the United States by Howard Zinn. And among the things it discussed at the time were things that got implemented after the Civil War. And not only things that got implemented after the Civil War, but that there was an entire time frame during which there was a emergent leadership in the United States, in states specifically, that had been subject to law changes as part of Reconstruction that ended up, in some cases, even taking public office in unprecedented manners, and that it just kind of got erased. It just kind of got sublimated. It just kind of got lost. And that there was an entire history of a specific kind of civil rights struggle that also included, shall we say, a capacity to engage with and potentially change the terms of actual service in government following the Civil War. That was very distinct, both in character and comportment, than what ended up emerging in the face of Jim Crow much later. Now, this is what I studied while I was on the job earlier, right? In San Francisco, when I was just making that transition out of so-called having some sort of problem that I needed assistance with, and I needed to transition into being able to work in a job. This was part of the transition. What I didn't know at the time is that the United States had also obligated itself to hundreds of billions of dollars worth of bond debt as a result of the Civil War. And a great deal of that bonded debt was actually in Europe and with Europeans. And that it had staggered terms. That some of those terms were 10 years, some of those terms were 20 years or more. And I contend now that there was actually very significant matters at hand. That when they created that original debt after the Civil War as part of Reconstruction, that also compelled closing out on pre-existing contracts that they had for their property, including considerations of what kind of property was going to be assessed when it came to determining collateral that was going to be made available in consideration of whatever the bonded debt was associated with the Reconstruction. And that questions abound as to how comprehensively the nascent generation of black leadership, including black political leadership, black institutional political leadership in the United States, was availed of the nuances of the specific kind of financial systematology that they were trying to reconcile with. The bonds, the deeds, the insurance on the bonds, and how many of them were allowed to play at congressman, state senator, until what? That bond came due? Well, if it matured, you needed to leverage debt associated with slave bonds as part of the Reconstruction. What are you going to do with that? I contend there's ample evidence that there was a very comprehensive plan to do something with that, right? So the question becomes, are those contracts still binding? Contracts on actual people as property. Presumably, slavery's been made illegal. Well, we had a pre-existing contract. You had a pre-existing contract, but then somebody got a bond in order to engage Reconstruction as a result of a war effort. And what do you consider the understanding of the proper maturation on that bond? How do you get paid back for your investment in that kind of Reconstruction? Are you talking about those lost slaves as property you've been deprived of? Or was it prosecuted as a crime? You were a criminal. Well, I mean, technically, the law of the land said that slavery was legal. And, it costs money. You hear this sometimes. Some people say this. Slavery is very expensive. On a very specific level, especially when you're talking about particular kinds of economic priorities, slavery is very expensive. And it's incredibly expensive if you engage in escalations and you end up losing. And then you have to consider your property basis when it comes to evaluation of the losses. We've never actually had an appropriate accounting of that, have we? I don't think we have. That's one. But there's more. Let's see what else we got.